Welcome back. It's another episode of the Freight 360 podcast. We are up to 319. It feels like just yesterday we started recording these, but come a long way. We've got special guests again today. It feels like we've been doing a lot of guests on the show lately, which is awesome because we're able to bring in folks who are experts in their field and we have a little knowledge on, but this is good. We're going to talk more on the freight collections and legality of certain situations today. We've got Christina Bellival back with us again. She joined us last month. So, Christina, welcome back to the show. How are you today?
Good. Thank you, Nate. Good morning to all.
Awesome. Good morning. And we are joined by Edgar Davidson, another freight collections specialist, as I might say. So, Edgar, welcome to the show. For those that don't know you, which probably most of our listeners aren't familiar with you, just a quick rundown on who you are and what you do. And we'll dig more into your specialty alongside Christina throughout the episode today.
Sure. I'm Edgar Davidson. Thank you, Nate. I have my own firm, Davidson Law Firm. We specialize in freight collections for motor carriers for trucking companies. I'm also general counsel for Baxter Bailey and Associates, nationwide freight collection agency.
Awesome. Well, we appreciate you both being on the show today because the collections and legal side, when it comes down to payments and whatnot, Ben and I have sat in the broker seat. We both have been exposed to the carrier side too, but the legality of it all is not necessarily our expertise. So we appreciate you guys. Ben, what's going on in Florida today?
Man, nice weather. Fall. Finally outside of summer. Football season's underway. It was a good weekend.
Yeah.
I was surprised the Steelers won.
So I was down there last week, and it was great weather. I mean, it had like the occasional rain here and there, but like you can't ask for anything better than like 80 degrees and sunny, and you get a little overcast and whatnot, but just wonderful versus like going in July when all you wanting to do is run to the closest building that's got air conditioning. So yeah. Quick little sports here. The World Series wrapped up. It was a good one. 7-game series. Here's what I thought was interesting. It was I think it was game 4. Went like 18 innings and set the record for the longest, like longest World Series game ever. And it broke the record of the night before my wedding 7 years ago, which was also game 4. They won 18 innings when my Red Sox lost to the Dodgers, the same team. So the Dodgers, and by the way, I stayed up for both of those games, just to see LA basically have a victory for them. But anyone from I'm in Buffalo, and the Blue Jays we are the farm team for the Blue Jays. So you got a lot of Jays fans here. So once the Red Sox and the Yankees are knocked out, pretty much everybody hops on the Jays bandwagon. But 7 games, and I really thought the Blue Jays were going to win it. They were up like in the 8th inning, and then Dodgers tie it up. Goes to what did it go to, like 11 innings or something like that? Edgar, did you see Game 7?
I did not stay awake.
Okay, but yeah, then the Jays won it, and I
was rooting for the Blue Jays, but
okay, gotcha. Ben, football, Steelers, man.
Yeah, I was pretty shocked.
Yeah,
honestly, and I rarely bet on sports anymore, but I almost put a bet on the Colts actually, and I couldn't get in the Hard Rock app, which is like the only one that works in Florida, because literally the kickoff was, and I was talking to my dad, and he's like, "Dude, I can't believe they're getting 3 points." I'm like, "There's no way they cover," and I was telling my wife, I'm like, this is probably like literally the only game I felt like I wanted to bet on all year. And I'm like, well, I didn't get it in anyway, so hopefully the Steelers win. I was like literally shocked. I was like, wow. And then obviously watching the Bills beat Kansas City was a nice little
yeah, man. So I was at that game. That felt good. I will say this, that like it really felt like in a typical Bills-Chiefs game, the Bills tend to lose not to the Chiefs but to the refs, and the refs, they played fair. They played fair on Sunday. So, good showing by the Bills there. Kansas City's in a rough spot right now. They're like 3rd in their division, not even in a wild card spot. So, Edgar, did you see that one at all? Bills Chiefs?
A little bit, yeah. My partner, she's a Swiftie, so that makes her a Chiefs fan.
A Chiefs fan, of course. All right, fair enough. Christina, are you an NFL girl at all?
No, not at all.
Okay, all righty. Ben, speaking of the Colts, I don't know if you saw yesterday was a trade deadline for the NFL. So you had the Colts got Sauce Gardner from the Jets. The Jets basically just dumped their entire team, but they got a ton of first and second round picks in the next couple of years. So who knows? We'll see what happens. In news, I think the biggest thing, this came out last week from the FMCSA or from DOT really. Secretary Duffy said he's going to start putting the responsibility for the non-domiciled CDLs. He's going to put it on the shippers too, right? Saying that not only do carriers have to conform, but shippers need to be responsible for knowing who they're loading. And that's a really interesting situation because that kind of inadvertently loops brokers into the equation. Ben, I don't know if you had any thoughts. I know me, you, and Steven kind of texted offline about it, but where do you think how do you think it pans out?
It's all anecdotal, but I've definitely heard from folks at larger brokerages that they're getting way more strict on this in regards to verifying English proficiency with driver check calls. But honestly, I don't know. I have a really hard time with the liability being pushed towards brokers or shippers because the FMCSA is just so far behind in really doing anything. And the information available to do any of this is just not there. And it's how do you hold either party accountable when it is nearly impossible to be able to verify either of those things?
The other thought I had too is what if the shipper is not actually the customer who owns
blind BOL? That happens all the time.
You've got all kinds of situations where literally someone else, the receiver might be the actual customer who scheduled the truck to go pick up at some location, and the location that's the actual quote unquote shipper, they have no idea how the truck was vetted or any of that driver level information. So it's yeah.
And then the other piece, I've seen, again, it's just basically anecdotal people talking about it, but I don't really understand the actual ELP. What is the standard for English language proficiency? Is that super clear? Is it something that a shipper would be able to even execute or do, right? Because I don't know, being able to determine language proficiency is rather subjective, I think, for a lot of different reasons. So I don't know how you actually would do that.
I haven't done the research on it, but I'd be willing to bet there's some sort of test similar to when you go and try to get your learner's permit or your license. There's the written part. I'm assuming there's something along those lines is my guess, but I don't know. I think it's all fluff. It's you get a lot of just the kind of the media effect, hey, I'm going to say this, but in reality, what are we going to do? So I don't know. Anyway, and then you had did you see the plane crash in Kentucky last night at the airport?
It was UPS, wasn't it?
Yeah, UPS. So
7 people, I think, confirmed so far died in the crash, but it also crashed into a warehouse. And I think as of this morning, 2 or 3 of the workers at the warehouse were still missing, and they were still pulling together information on it.
Yeah, sad to see that, man. Crazy. You got a fully loaded plane with fuel to go to Hawaii, right? And it crashes on takeoff. So a lot of jet fuel just burning up there. So
I think it was 38,000 gallons is what I saw this morning.
That's nuts. So well, sad to see, but hopefully there's minimal fallout after the fact on that one. So, all right, well let's get into collections here. So I know Christina, we talked with you in quite detail last month, and now we've got Edgar on today. So, Edgar, you shared with us your outline. What do you call your elevator pitch on this is what I do, right? So I wanted to kind of set the stage a little bit with What is it that you do specifically at your practice? I know you mentioned you're also with Baxter Bailey, but just kind of lay it out for us, and then Ben and I got some questions for you and some situations we kind of want to talk through.
Sure. Can you hear me okay?
We got you.
Yeah.
Okay. Yeah, I'm general counsel for Baxter Bailey and Associates, but as a part of our process, once a claim goes through collections, it comes to me. So then at that point, I determine if a case needs to be litigated. At that point, I have to analyze uh, the bill of ladings and rate confirmations and all the shipping documents to determine whether the shippers and consignees have liability, and if the broker or any other third parties have liability. So this is basically my job. I determine what jurisdiction that the case needs to be filed in. We send a lot of matters to Christina in Texas, and if I can file it myself, I do. I'm licensed in Tennessee and Arkansas, so in those states I will file. But we work with attorneys all across the nation to file these. But
let me ask you this:
and if you
on that note, what determines the state in which it would be filed? Is that based on the headquarters of the shipper or of the carrier, or what does that look like?
That's a very good question, and it can, we could talk all day about jurisdiction, especially in transportation, because you have usually 3 or 4 different parties in 3 or 4 different states for an interstate shipment. You could file it where the shipper is, potentially. You could file it where the broker is, potentially. Some cases you have 2 brokers, so that could be 2 different states. You could file it where the consignee is, the receiver of the goods. There's also the potential you could file it where the carrier is located as well. So you have, several jurisdictions you could pick from in any given interstate shipment. Now, in an intra-state shipment, which is within the state borders, one state, then obviously you're going to file it in the state that it was shipped in.
Okay, gotcha. So, and I want to kind of remind folks, if they haven't listened to the last episode, one of the big things that Christina hit on is if you're going to go the legal matter of collections, right? Let's say it's just a carrier directly with a shipper, right? If you're going to go the legal route of collections on a customer, you have, for all intents and purposes, you've kissed that relationship goodbye. It is not going to be revived once you've, serve legal papers to your customer, or you have a lawyer attorney serve legal papers to your customer, right? So, I want to ask both of you, when it comes to a client of yours, it's yeah, this is unpaid, and they're trying to figure out, do we go the legal route? Is there a percentage that they're able to work out without legal matters, or I guess what does that look like when you cross that line of yep, we're going to sue them? Does that question make sense?
Yes, it does. I have,
and the reason I ask is, as a broker, right? We try everything we can before we're signing this to collections, because we know as soon as we do it, we're never going to work with that customer ever again. That's our assumption, at least.
Yeah. And what you're talking about is a business decision, and that's something that you certainly have to consider. Instead of just the pure legalities of it. I mean, you may have a strong legal case, but you don't want to tie it. You don't want to sever that business relationship. And like you said, once you file that suit, that relationship is probably not salvageable. But I have situations where we've already filed suit, or prior to suit where a shipper or a broker um, will come to me and say, "Hey, we'll agree to give you, future loads or whatever if you drop this." Some kind of, equitable deal like that. That happens fairly often, actually. Uh, so that's something that certainly we will consider if the client or the carrier really wants to work with the broker and not sever those ties, or if we represent a broker and it's the other way around.
Okay.
I would
And
also add that when you have a collections agency working on your behalf, it is more likely to separate yourself from the collection agency and let the client know, for instance, that I can't absorb this debt on my own and I need to send this out for collections, but future loads we can continue working with you because you have sort of a buffer. You're not suing them directly. It's Baxter Bailey that's suing them on your behalf, but they got an assignment from you.
That's
So you
interesting.
have that.
Yeah, kind of like the
Yeah,
concept of like I'm not the bad guy, but
yeah, exactly.
what makes the most business sense for me is to go this route, and they're gonna they're gonna be the quote unquote you know bad beast knocking
Bad
on your
guy.
door. So yeah,
right,
Yes.
good cop
that,
bad.
that's a
Yeah.
that's a very good point. Once it goes to Baxter Bailey or some other collections agency, it's generally assigned. So that the carrier a lot of times is not even the named plaintiff. It'll say like Baxter Bailey as a assignee of you know whatever trucking company, ABC Trucking Company, um, or even just Baxter Bailey versus whatever shipper or broker. So that's a good point Christina made.
Okay.
And I think what's going to be helpful too is like, let's just go through the most common situation for anyone that isn't kind of familiar with how these play out, right? So it's like shipper gives the load to a broker, broker books a carrier, broker talks to the carrier, broker runs the load is delivered, everything is fine. Broker then gets an invoice from the carrier they believe that ran the load, okay? And in some cases, there's even tracking involved. So from every point of view, the broker looks, verified the trucking company, looked at the insurance, tracked the MC, load is delivered. Then the carrier sends the broker an invoice with the POD, the proof of delivery signed. The broker then pays the carrier, and then broker sends the invoice to the shipper. Shipper pays the broker. Everyone has moved on, moving other business, right? And almost all of these, what we see is like 45 days later, an email comes from a carrier that says, "Hey, I ran that load for you, broker. You owe me money." And then the broker goes and looks at their TMS and goes, "I don't know who this carrier is. This
Or
carrier didn't
it
run the
comes from the
load."
customer because the carrier doesn't know who the broker
Yes.
is, right? And they go, "I know I
Correct.
picked up here," and the customer's
Yeah,
like,
you're right.
"Hey,
So,
Mr. Broker,
yeah.
dude, take care of this. I already paid this. I already paid you guys on that."
Every one of these I've seen, it was initiated by the customer, where you get an email from the customer that has a carrier in copy and says, "Hey," because the carrier knows they picked up the load. So they reach out to the facility. They go, "Hey, this is the PO. I moved for you on this date. Here's the POD. I haven't been paid." And then the broker is looking at it like, "I don't know who this is. What happened?" The shipper goes, "Hey, take care of this. I've already paid you." So the shipper's paid the broker. Broker has paid the carrier they believed ran the load for multiple reasons. Tracking, spoke to them, verified it, and got a POD from another carrier. Now all of a sudden there's another carrier that comes up and says, "Well, now you owe me money." And the shipper goes, "I already paid you, broker. I'm not paying twice." So then the broker then has to usually make the decision of, do I pay this second carrier, or how do I verify that this is true in the first place, right? So I know in a lot of these scenarios, the broker will ask the new carrier that has shown up and said, "I ran this freight and didn't get paid. Hey, can you send me an ELD? Can you send me some verification that I can see that shows you ran this, just so that like we understand and can kind of work through this?" Then you get them. And then normally in these scenarios, like Nate said, and I think, also Edgar pointed out, I was like, most of the time the brokers will make a business decision, realize that this carrier ran the load, will find out that something fraudulent happened with the carrier you believed ran the load, and usually either pay that second carrier, or that's when you guys get involved. And like from there, can you kind of explain to people how and who is responsible and why, right? Because you have a carrier that clearly ran that load, right? Did not get paid, and then you guys get involved. And then this is where I think a lot of confusion is on the broker side and the shippers of like, well, that's not our fault. We paid this other carrier. We don't know who this is. Who is responsible for making sure that carrier gets paid? And I guess why, for anyone out there that's trying to understand it.
Okay. Yeah, in the situation where the carrier is not paid, um, both the shipper and the consignee, which is the receiver of the goods, can be liable legally. Um, the bill of lading is the controlling document on all interstate shipments, and every load has to have a bill of lading, which lists the shipper and consignee. And the carrier. The controlling case on this is Oak Harbor versus Sears. It says that the consignee, shipper, and broker are jointly liable for unpaid freight charges to the carrier. So, based on the law, the carrier, if they're not paid by a broker, then they can go back to the shipper and say, hey, your broker did not pay. I need paid for this load, and can legally go forward against the shipper and the consignee. There's more law. There's a statute that makes the consignee liable as well. But in that situation, like you said earlier, the shipper's going to go back to the broker and say, hey, I already paid this. I paid you. You were supposed to pay the carrier.
So in that case law, there was a broker involved in the middle?
Correct.
So
Correct.
the shipper paid the broker never paid the motor carrier.
That's correct.
Okay.
And that's the situation we run into daily. I mean, that's what, Christina and I do for a living. And there's a case, it's called Excel Truck Lines. It states that the bedrock rule of carriage is absent malfeasance, the carrier gets paid. So there's a public policy.
What does that mean in like non-legal speak?
Yeah, it's basically if the carrier didn't do something wrong or scammy, or was not a part of the scam, then they should get paid.
Okay.
For hauling the load. And the policy, or the public policy consideration, is this carrier spent their time, money, fuel costs, labor to haul the load, and everybody got their services provided to them, but the carrier is out money. So it's not equitable that the carrier gets stiffed in that situation.
Let me ask this, because in a situation like that, why wouldn't the carrier just file on the broker's bond? Or is it in most cases the brokerage is out of business?
The carrier generally will file on the broker's bond, but you run into a situation, even on the $75,000 bond, if this broker has multiple debts that they have not paid, which is the case with many of these, the carrier is going to get pennies on the dollar. They're not going to be made whole for the shipments they're making.
So then they can go file the remaining amount on the shipper? Is
yes.
That okay? All right,
that's correct.
Because I mean, like what I've seen when I've seen these play out in the past, like usually a broker mismanages money. I saw this a ton during COVID, where like money was great, everyone was doing well, and then all of a sudden like rates dropped, and a lot of brokerages that didn't know how to manage their money couldn't afford all the stuff that they were paying for. When the money was good, they had this sweet office and this sweet car and all the, going on. They're just blowing money, right? And then all of a sudden, when rates are down and they can't keep cash flow up, they're trying to like slow pay carriers and trying to make it up. And next thing you know, they're like, we got to shut the doors, right? And I've heard carriers saying like, we filed on the bond and we didn't get, we either got nothing or we got, like you said, pennies on the dollar. Yeah. So that makes sense.
And that happens all the time, and it's very rare that a carrier gets made entirely whole from filing on the bond. Ideally, that they will, but it rarely happens because there's going to be, if a broker goes out of business, there's not just one carrier that's owed.
Here's the other two questions I'm curious, right? Is we talked about this like off air. Is the other really common thing we see in the industry is broker books a carrier, that carrier gives that load to another carrier, right? Now, like it's commonly referred to as double brokering, but I think it's better defined as like unlicensed brokering because a motor carrier's
fraudulent
NC,
brokerage activities is how the TIA has coined the term.
So that means, hey, I book a carrier and that carrier gives the load to another carrier. Well, that carrier doesn't have the license to arrange transportation with another entity. And the carrier, okay, go ahead.
Well, sometimes the scams will have a brokerage authority and a carrier authority, and that's how the scams ran.
Dual MCs. And then there's a second one too that I want to talk about where like I book a carrier, that carrier then impersonates a legitimate brokerage to book a legitimate carrier, right? And then that carrier doesn't get paid. But to just separate them for a second, right? Like I book a carrier, that carrier gives a load to another carrier, right? How or what does that complicate things, make it more or less difficult for the carrier that actually ran the load to be able to get paid if they are willfully taking a load from another motor carrier? Does that make it easier or harder for them to be able to collect on an undue freight charge?
Yeah, I'll let Christina take this one. It's a good question.
Yes, my experience is that it does make it harder for the carrier to collect under that scenario because you should know the law. And the law says that carriers can't broker loads. So if you take a load from another carrier, you run the risk that you will not be able to collect from the shipper or the consignee. But in some instances, shipper and consignee do not know that that was a carrier that gave the load to another carrier. So it's not going to prevent collections always, but it's going to make it more difficult.
Right.
Sure.
And that's one of the reasons why when we talk about this is like, we have a lot of carriers that listen to the show that we work with that like, this is just a really good best practice to be aware of when you're doing business, right? Where and verifying who you're getting business from. Because the thing I was curious is, you said this a moment ago, Edgar, was an absence of malfeasance, right? So I was looking up legal definition of malfeasance, right? To like literally read what that is. And again, this is literally Google. So correct me if I'm wrong, but it's unlawful or wrongful act, right? But misfeasance is neglect, right? And is there a difference? Because in one, if I'm a carrier and I take a load from another carrier, to me, that is at the very least a wrongful act, maybe not unlawful, but it is certainly not legitimate, I would say, right? Like,
And that's a good question. I think that's a factual question. What is malfeasance really, and what acts constitute malfeasance, and that's not really defined. But I think that really the if the carrier's not actively doing something, fraudulent or involved with the scam, then I think they do deserve payment. To what extent is an omission by the carrier grounds for non-payment is it's really a question for the court or the jury if it gets that far.
Yeah, and the reason I say this is like Nate and I talk about two things that are probably like the simplest things that can avoid this for people operating in the industry, right? From the broker side, making a phone call to the FMCSA phone number and sometimes the previous one to verify you're still doing business with the company you think you are. And the same thing from the carrier side, right? And every one of these that I've worked through for a carrier that has reached out like, hey, can you help me with this? What should my next steps be? Is like, I'll look at the rate con and there'll be a broker's name on it. And the first thing I look at is the domain correct? Or is that really the brokerage you thought you were doing business with? Or literally just making a phone call to that brokerage and saying, hey, does this person work there? And in a lot of these, they're like, oh, yeah, that broker doesn't work here. And oh, that's not our email address or our domain. It is like one letter off. So the carrier, right, being the victim of fraud, thought they were doing business with a legitimate brokerage, but that person didn't really work there. The domain was fraudulent and the websites were not accurate, right? And again, like if I'm doing business as a carrier with a new broker, just that phone call to verify that who you got the load from is from that company and is legitimate, I think could avoid a lot of these things for them, right?
Also another thing that carriers should do is check on the Safer webpage if their bond is still active.
Yep.
Because if their bond is canceled, they already started not paying.
Yes.
Oh, that's
those
a good
are great points.
Yeah.
Very yeah. And for the what we call the lead broker, the legitimate broker, when you're hiring a carrier, you go on Safer and you see that they have a few trucks but no inspections whatsoever. I mean, that should raise some red flags.
Yes.
Yeah.
And I think over the last few years, our tools and our processes and our, just self-education on these scams, I think it's come a long way, and we're doing a better job as brokers to vet carriers. I think a lot of times the victims in a lot of these cases is the owner operator who, doesn't have the time or the technology to try and vet every broker out, and they choose to just blindly trust whoever they're talking to, right? So yeah, I mean, I think on the brokerage side we've done a good job at it, but I still think it's going to be a really tough thing for some of these smaller carriers that just like I said, they just don't have the time or the capability to go as in depth as we do as brokers, because we sit behind a computer all day long. They're behind the wheel the majority of the time, and it's really difficult. So
yes,
and to put numbers on this, like
what's that?
Freight Caviar had this out this morning.
Okay.
So the estimates, the most recent estimates I've read were literally this morning. They were talking about new scams that are being perpetrated like across the whole supply chain. And the newest estimate was $32 billion in 2025, which was likely a 25% increase over last year, right? So it's literally like $8 billion more was stolen in either funds to carriers, right, brokers, or just outright cargo theft, right? Just over last year. So like this is not getting better. It's getting worse, and more people are becoming victims of these things, right?
Yeah. So I've got another question, a little pivot here, but one of the things that we're often asked to do as brokers, as a value add to our customer, is they're like, hey, can you just, can you get the BOL created for me and send it over, right? So that's one of the things that we'll often do. And I'm curious, the box that says third-party charges, right? If the broker's information goes in there, does that have any weight at all to liability to pay the motor carrier listed on that bill of lading? 'Cause I know we said the bill of lading is a legal document, right? It's going to have the shipper, the consignee, and potentially third-party charges. And even there's a box for prepaid. So I'm curious, where does all of that play into when it comes, when the rubber meets the road, who's liable in the situation where maybe prepaid is checked but it wasn't prepaid, or maybe a broker's listed as third party? How does that pan out?
Okay, good question. These are very good questions, because the bill of lading is so important to collecting freight charges. As far as third party, that just makes, in my opinion, that makes extra liability, like almost extra liability on whoever's in the third party. But legally, they're not a shipper or consignee, so they're not technically liable under the case law. But I would say that once somebody is entered into the bill third party, that company is a part of the bill of lading, which is the contract between the parties. So I would argue that that party is liable.
So, so I have a question. Just on that, before you go beyond that, like what are some best practices? Because in some cases, like the shipper asks the broker to create the bill of lading, right?
Mhm.
And in some cases, the broker puts their company name on the bill of lading. In some cases, the shipper's name is on that bill of lading. In some cases, the consignee's on it, and neither are, right? Are there any things that you could say like should be happening that make, I would say, are best practices for just bills of lading, right? Are there increased liability if the broker's creating the bill of lading, right? Should they make sure it's not their company name on it? Should they make sure it's the shipper's? Should the carrier be writing their name on the bill of lading for the POD? What are some of the things that people, I guess, should be aware of related to that?
I mean, I don't think a broker should put their information on the bill of lading. You see it all the time. You see the broker's name in the carrier box. That's not proper. The actual carrier should be listed as the carrier on the bill of lading. And carriers need to make sure that their name is on the bill of lading, even if the broker's name is printed on the box. I think, the shipper, the actual shipper of the product needs to be in the shipper box. The receiver of the product needs to be in the consignee box. Now, if you want to put bill to third party and put your information in just to assist the other parties, I don't think that hurts you, but I do think it could potentially create liability based upon the contractual bill of lading.
Right.
Yeah, the reason I've seen that.
Add that.
Go ahead, Christina.
Wait, I wanted to add that for the shipper to be excluded from liability under the bill of lading, there's what's called the Section 7 or non-recourse provision. So if you are the shipper and you do not want to be liable for those shipping charges, you should check that box or sign your name where it says non-recourse Section 7. And then prepaid is a defense for the consignee as long as the consignee can demonstrate that they in fact prepaid that shipment.
Where is that non-recourse?
If the consignee wants to be released from liability, they have to check the prepaid box and they have to save evidence that they in fact prepaid.
Okay.
Yes.
But another catch is that if both Section 7 and prepaid are checked, they invalidate both. And then everyone's liable. So the carrier's going to get paid by one.
What is the Section
But it
7
can't
part?
be
I'm not
both.
familiar with that. Is that on a bill of lading?
In
Yeah.
the standard bill of lading, you look at the portion that says non-recourse or Section 7. It says that the shipper is not liable and the carrier has to collect from the consignee.
See, this is Ben, and this is like for the broker audience out there, right? These TMSs that are out there now that create bills of ladings, they are not all standard and have all the same stuff, right? And that's where, like, I've seen systems that create a BOL that doesn't even have a place to sign, like at the shipper, at the receiver, for the driver, and I'm like,
Yep.
how can you pass that through as a bill of lading? And they're like, well, it's more like a POD. But that's
Can I
interesting.
ask?
So
There's
And
I
that's
wasn't familiar
super
with that
helpful.
non-recourse part.
Well,
There's
here's the other
also-
question. Go ahead.
go ahead.
No, finish that thought, Edgar, because I was going to ask like
I
another
was just
question
saying
tangent to it.
that most people don't even see the reverse side of a bill of lading, which is standard on what they call a uniform bill of lading. There's nothing uniform anymore, though. It seems the bill of ladings are all over the place, like Nate was saying. But there used to be a standard form, and it's still used, and you'll see it on a lot of bill of ladings. It's called a uniform bill of lading. And there is a reverse side of that, which has terms and conditions. But most of the carrier never sees that.
Yeah, they don't scan them in either. Like you never see them on the invoice. It's always just the front side of it. Because I was thinking about when you were saying Section 7, I was thinking of Nate's question. I'm like, oh, I've seen the back of literal original ones that have this on there. But when we get them, it's always the scanned face of it, right, with the carrier's invoice. So like we rarely see the back end. And then to Nate's point, all these TMSs just create them with whatever information they want to put on it, which just completely unstandardized them.
Right,
Yeah.
but
So if you're the broker and you're creating the bill of lading, you should use the uniform bill of lading. And since you're doing it for the shipper, you should sign the non-recourse provision. So if your
So
customer isn't going to be liable, you're not going to be liable either.
I'm literally taking a note to do that later.
Yeah. Where does one find a uniform bill of lading?
You can Google it.
you can, yeah, it's online.
Yeah.
All right. Got some
here's
homework to
the
do.
It's pretty easy to find. But yeah, there's a box on the front that says subject to Section 7, blah blah blah. That's where the shipper should sign off on it if they don't want to be liable for the freight charges.
Okay.
But Christina, like Christina was saying, bill of ladings can be prepaid or collect, and you'll see it. You'll see them marked.
It's prepaid, collect,
either
or third
prepaid-
party, right? Are the three boxes?
Yes, and prepaid just means the shipper is responsible for the freight charges. Collect means the consignee is liable for the freight charges. So one way the shipper can get out of liability is if Section 7 is signed and it's a collect bill of lading. At that point, we don't have much against the shipper at all.
Here's
Gotcha.
the next question is, on a third party blind bill of lading, what and how does that either complicate it or make that less? So like, hey, I'm the one that is buying product from Edgar, that I'm selling it to Nate, but I arrange transportation to pick up from your facility to ship to Nate, and I don't want Nate to know that it came from your facility, right? Are there best practices? Because like I have a client right now that has a large customer that this is like all they do, right? Like everything is a blind bill of lading. They're all shipping from where they purchase, right? It's in the food industry. So like they don't want their customers to know where they're sourcing it from. So the shipper's name, they don't want their customer to see, because then the customer can just cut them out and order for them directly, right? So does that complicate things in any way or not? Does that change who's ultimately responsible? Since I'm arranging transportation, right? I'm technically the BCO, right? Even though I shipped it from your facility to Nate. But I don't want Nate to know it came from your facility. So are there any best practices to do in blind bills of lading?
I think it would turn on who issued or who was named on the bill of lading, but it's also going to be determined by who's the beneficial owner of the goods.
Exactly.
So
So even if you don't want to be identified, if it was a warehouse or it was someone, whatever, we're going to pursue that party and they're going to say, no, but we didn't own what you were
Right.
shipping, and they're going to identify you, and then we will pursue you. Even if your name isn't in the bill of lading, you're technically the shipper.
So here's
still
a question.
you're still
The
the
question
ship-
I always have is it more about who arranged it? Because owner of the goods literally changes, right? Like I purchased it from Edgar, but once it got to Nate, it's FOB delivery. Nate owns the goods once he receives it. So does it matter when you're determining the owner or who's arranging the transportation?
So the shipper is the one who arranges the transportation, even if they're not identified as such. But the consignor is who surrenders the shipments, and the shipper and the consignor are jointly and severally liable.
Got it.
So, but if you can demonstrate that you're just an agent, that you are not the true shipper, then the warehouse is going to get out, or whoever was selling it on your behalf is going to go out.
So I have one
And
last
you're going to
question
step
on that.
into the shipper shoes.
Got it. And that makes perfect sense, right? Like I arranged the shipment from Edgar's warehouse to sell to Nate. I'm the one that is technically the shipper, even though it was picked up from Edgar's facility, right?
Yeah.
Now, the question I have, because I literally ran into this last week, is the same scenario, right? Like I arranged it from Edgar's warehouse to ship to Nate, but Edgar's the one that created the bill of lading. His team at his warehouse created the bill of lading, and the bill of lading did not have all the information it should have had. In this specific case, they did not put the temperature on the bill of lading, the legal document. And a claim arose, and the carrier's like, well, hey, there's no temperature on the legal document. So how are you going to tell me I didn't do something you literally didn't put in writing. But I'm the shipper, but I didn't create the bill of lading in this case. Like, how does responsibility get unwound in a scenario where the shipper isn't the one that's legally creating that legal document, I guess? Or should I make sure I'm creating the bill of lading to give to the carrier, or to send to Edgar's warehouse to make sure he gives it to the driver? Like, how would you, like, procedurally, should that be done, I guess, is another way to ask it.
So in that scenario, I would say that the warehouse does have liability for the loss because they have the obligation to instruct the carrier as to what temperature has to be maintained. The carrier doesn't have any liability because they weren't given that instruction.
Right. The carrier's not contractually obligated to keep it at any temperature if they're not on notice of it. That's a dispute.
Now, when you define
between the
notice,
warehouse
if it
and the
is,
shipper.
so then the question is defining notice, because the carrier had email written confirmation of what the temp should be prior to pickup, and the facility that didn't put it on the bill of lading said they verbally told the carrier, which is obviously there's no way to verify, right? So it happened in two different ways, but the email correspondence to the carrier prior to arranging this, right, at least is written, but is certainly not on a legal document, right? And a rate con, most people think is a legal document, which it isn't, right? It is the bill of lading, right? Does that in some way make that more or less clean to determine responsibility?
I would say it would be a fact issue at the end of the day for the court to decide, which makes it much harder on part of everyone to collect. But I think that the carrier may have liability in that case because they were given notice, even if it wasn't included in the bill of lading.
Yeah, I agree with Christina on that. That's certainly a fact issue, and whether that was sufficient notice to the carrier is, I'm not sure. Yeah.
Interesting. So I did see in your notes here, and I didn't think about this, but a broker carrier agreement, or even for that matter, like a shipper broker agreement, right? We sign these all the time. If there's a clause in there that states like that the shipper basically says like, hey, we're not liable for, if the broker doesn't pay or whatever, is there any, it sounds like no matter what the agreement says, the law trumps any of those clauses that someone might try to put in their contract. Is that accurate?
Well, there's two different agreements. There's a broker carrier agreement, and there's the broker shipper agreement. So, we deal mainly with broker carrier agreements. And some of those agreements have clauses in there that says, you're not allowed to contact the shipper or consignee, even if we don't pay you, and it's a pretty draconian clause, but it's, snuck in there with the 8-page document that these carriers just, basically click through and sign.
Yep. They don't read them. Yeah.
But some of the courts say we don't care what, that document, could be voided if you don't get paid, because it really it's that means the broker has breached
a contract, essentially.
Breached the contract
right,
by not paying.
They breached the whole agreement by not paying you. That was a material condition of that whole agreement. And non-payment by the broker is my argument that the carrier shouldn't be held to the broker carrier agreement if the broker does not comply with the broker carrier agreement. It's a breach.
Yeah, another thing is that the shipper and the consignee are not a party to that broker carrier agreement. So as third parties, it's more difficult for them to enforce that agreement unless they can prove that the purpose of the agreement was to benefit them, which is very hard to prove.
I was almost thinking if like a shipper, because I mean, Ben, you and I have seen some of the most outrageous language in contracts, and I know we're not having that discussion today. We've done that before, but I'm almost wondering from a broker's perspective, like if a shipper tried to put a clause in there that like basically prevented them from having to double pay a shipment because we got double brokered or something like that. Like, I'm almost wondering if, like, that's something that a shipper has ever tried to do, saying, like, hey, in our agreement, broker, if you fail to pay the right person and that person then comes back to us, we're not liable to pay them. You still are. Have you guys ever, has that even come up as has that,
Actually,
has anyone thought
yes.
of that or talked about that?
So, yes, that did come up in a very large case I'm handling right now. The carrier has no privity of contract, so the carrier can't be held to that. That's between the shipper and the broker. Carrier can still go after the broker in that case.
After the shipper.
After the shipper, okay.
And the
Oh,
shipper, right?
I mean, yeah, I'm sorry.
Yeah.
The carrier can still go after the shipper.
So
in
the
that
bottom
case
line in all of this is that the shipper
Exactly.
is responsible to pay whoever actually performed the services of transporting the goods. That's like the bottom line here. And we went down like a rabbit hole of different like scenarios and situations, and it really brings up, just thoughts
Well,
on
Nate, unless they execute the Section 7, they do have a way out.
Then it's the consignee, though, right? So it's
Yeah.
one of the two, right?
Yes.
And the way this was explained to me when I first got into the industry was, at the end of the day, somebody owns something, somebody used effort and money and time to move it. The person that owned that goods benefited. The company that moved it provided the service. It doesn't matter what any of the paperwork says, who money changed hands, or what anybody did in between. At the end of the day, if the company that moved it didn't get paid, the company that benefited from having it moved is responsible, right? Like, is that a fair summary of?
I think that's a very fair summary of the policy argument. Yes, you've got a carrier that has spent time, money, and cost, labor, miles on the road to haul this product. Shipper, you got your product shipped, you got everything you asked for. It's not fair to stiff a carrier in that situation.
Before we're recording here, you brought up, you tried to compare it to like construction and subcontractors. Can you kind of paint that picture of how it would look in a different industry, so we could take ourselves out of transportation and see it from a different perspective?
Yeah.
The concept, at least.
Right. So in this case, let's see.
Is this like if I build a house and I hire a general contractor to build the house, and that general contractor subcontracts, a dozen different subs, and one of the subs doesn't get paid, they can come back to me?
Right. That's correct. And
as long as they sent you a notice of intent to file lien and eventually file a lien, they can preserve their right to go against you.
Gotcha.
But it is similar to that, but carriers don't have that need to file the lien unless they're doing construction work or mineral liens.
Gotcha. Interesting.
But it is an issue of equity, and that the law recognizes that benefit for the carriers, and the same thing with the subcontractors.
All right, so
I always explain it this way, like, Nate, you hire me to mow your lawn. I go out and mow your lawn, but then you pay Christina. You say, here's $50 for Edgar. You go pay Edgar for mowing my lawn. Christina runs off with the money. Well, you still owe me, Nate, for mowing your yard.
That's a very simplified way to put it. All right, so
I think that makes so much sense too. Like, I'm going to use that analogy.
Kind of makes brokers look bad in that essence, but
I mean, that's how I explain it to like my kid.
Yeah, no, that's good. That's good. So
Like
Christina kind of gave her opinion on like when to go the collections route. I'm kind of curious, Edgar, just to wrap it up from your perspective. If a carrier's coming to you, you said you don't work with brokers, or do you work with brokers?
We represent some brokers, yeah.
Okay. So if a broker or a carrier is going to come to you and say, "Hey, I've got these $100,000 in unpaid invoices from these various different shippers or customers of mine, at what point would you advise them, yeah, we want to go you should probably go the legal route of trying to recoup the money here versus no, try to work it out at a lower level because you're going to burn the relationship. Is there like a general rule of thumb?
Generally, I would recommend going the collections route, such as Baxter Bailey and Associates, because they can do it a lot cheaper first, and they're able to do the early legwork and figure out which parties are potentially liable. There will be some initial communications with the parties, before it gets elevated for me to get involved and file suit.
Okay.
So that would be the initial steps.
And then can you on that note, can you kind of explain just in simple terms what happens behind the scenes on the collection side, and then what happens on the filing suit side?
Yeah, on the collection side, there'll be an initial intake where the carrier has to submit all of their documents related to the load or loads that they're not paid on. Generally, the collector will figure out if there's any bond money. If there's a bond to file on, that will happen. At that point, there's a reach out to the broker. A lot of times that broker has flown the coop, and they're out of business. That will be researched. What debts the broker has. In a larger collection agency like Baxter Bailey, there will be some precedent usually that they've worked with the parties in the past. Even a lot of brokers, we have relationships with, so we can reach out to what we call the lead broker, which is usually a legitimate broker, and say, hey, what happened here? Is this one you want to resolve? And a lot of times, those get resolved within weeks, and that's ideal for everybody if that happens. And sometimes it doesn't, and then a letter will be sent to the shipper and the consignee, which elevates it further. That's like, more elevation. If it doesn't get resolved, there will be usually some emails and calls with the shipper and or consignee. If everybody says, go bite dust to the collector, then that's when it comes to me, and I have to decide whether we're going to file suit on it and send it to someone like Christina or do what we will with it. And at that point, usually another demand will go out from either me or Christina and give them one more shot to collect. If not, then the complaint's filed, and then you get into full-blown litigation, which is costly and usually doesn't benefit a whole lot of parties. But
I would imagine it probably doesn't get that far in most cases, though, right?
I'd say not. I'd say
just because of how much it costs, right? Like, I can't imagine a shipper who's very clearly owes the money is going to be like, we're going to go fight this. We're not paying you.
Yeah, and the shipper has defenses. I mean, like as we talked about, they can argue, we signed Section 7, or there's an estoppel argument that is really not very effective, but just flat out, we've already paid this. Courts generally reject that these days, but it has been attempted. They call it legally, it's called estoppel. It's basically saying we paid this once, we shouldn't have to pay again.
Gotcha. Ben, you got any things you want to ask before we wrap up?
One last question I have that, again, it's more of just a curiosity, and we don't definitely need to go down a rabbit hole, but I am curious is fraud as prevalent as it is? Are you ever seeing instances where somebody's coming to you and saying, we're owed all this money, and they actually didn't move the freight just to be able to get a shipper or a broker to pay them?
I have had that happen numerous times where like carriers, they're like trying to be like, oh no, we hauled this. And we find out once we're like, yeah, we need an ELD download and all this. And then they just disappear. But like I've had that happen numerous times.
Yeah, and we take steps to vet our own clients because of that. we make sure that they did haul the load. I mean, that's why we ask for ELD logs and all that.
Yeah, because I'm like, if there's a way to steal money, someone's trying to do it in the supply
Oh
chain
yeah.
at this point in time. And I'm like,
and
just in the back of my mind, I'm like, I feel like somebody's probably out there also trying to do this. Like, oh, hey,
Yep.
that brokerage is going out of business. I got a bunch of bills awaiting here. Okay, we're just going to start trying to file claims against people.
it
Yeah.
does happen.
And that's where, to the broker community out there, because it's happened to my company numerous times, if a carrier comes at you and says, like, I'm the one who actually hauled this, you, like, respectfully challenge them and ask for the appropriate things, because it could be correct, right? If you failed to vet your carrier and all that properly, you might have got stooped and got double brokered. But there's also the chance, like Ben said, if there's scams happening out there, someone's probably out there trying to stick their hand in the pot too, and have some broker foolishly pay 2 trucks because they wanted to not have it go to their customer. Because that's what happened is they came to us and they're like, we're going to go to your customer and demand this,
Yep.
and you're going to lose them, blah blah blah. And we're like, hey, we want to pay you, we'll pay you, but like, please provide us the following things to prove that you were the carrier.
Yeah.
And they quickly just disappeared. So there is that scam out there.
Case right now that's going on where it was a factoring company and they purchased multiple invoices from this broker, and apparently their carrier didn't haul any loads, and they replicated those invoices and those rate confirmations using just information that wasn't accurate. And when I went against the shipper and the consignee, they're saying those loads aren't ours. And the broker said those are not valid rate confirmations. So it was all done by the carrier, and it was done against the factoring company.
Oof. So they duped the factoring company on that one then.
Yes.
Woof.
I've seen those, and I was also really kind of surprised the more I've worked with factoring companies that of what information like they are verifying and what they're just taking for granted, to your point, where it's just like, oh, all these loads happen. We funded all this money based on just rate cons. And you're like, you can just create a rate con out of any system. It is not a legal document. There's nothing else along with it. And like, you're just funding tens of thousands of dollars based on what this TMS sent you. Like, Nate had an agent we talked about in another episode that there was some fraud in related to like, weren't they like illegitimate loads where they were like paying a carrier they knew or something that was creating?
Oh yeah, this was
like fake invoices years ago.
This is a couple of years back. Yeah, basically like had all these, they weren't even real loads. A bunch of loads were created in our system, and he booked a legitimate trucking company in our system, and then created all these EFS checks, and the EFS checks were cashed by his son. So like to the tune of like $200,000, and it's part of a larger organized crime ring, and agent fraud is a whole nother conversation. But yeah, like unless you protect yourself as a business owner and brokerage, like there's a lot of ways that you're vulnerable from like different
factoring
angles.
companies, before they fund, they should reach out to the broker and confirm those loads are accurate and that they're gonna get paid. That's something pretty simple to do. And in this case, my client didn't do it, and they're off a couple of $100,000 because of that.
Alrighty. Well, we'll have to do another episode with you guys where we talk about something positive that can, we've got some good stories, right? So
we could go on for hours, but
yeah. Well, cool. Edgar, it was good to meet you and have you on the show today. And Christina, pleasure to have you back again. Christina, anything you want to wrap up with?
Oh, just letting everyone know we're here in Texas and we're available for consultation. If you want to get your freight bills paid, just reach out to me. And if you're nationwide, and you have Baxter Bailey there to help you as well.
Awesome. Yeah, we've got your website in the show notes too. So make sure to check that out. And Edgar, anything you want to wrap up with?
No, like Christina said, if you have unpaid freight charges or any issues collecting, you can go to Baxter Bailey and Associates. You can go to my website, davisonlawfirm.net. I have a blog that has a lot of legal information on it. And that's DAVISON lawfirm.net.
Yeah, we'll throw a link in the
It's
show
just
notes for yours too. That's a good point.
yeah, it there's a lot of articles on there that's very helpful for what we're talking about today. So
Awesome. Well, we appreciate that. And thanks again, both of you, for being on. Ben, final thoughts.
Whether you believe you can or believe you can't, you're right.
And until next time, go Bills.